respond.
Mahesh.
Hey, hi.
Hi.
Appear alongside Mr. Kelun.
I appear alongside Mr. John Jomo.
Present,
Ms. Sarah Chege. Conference, but perhaps before you do that, please Mr. Manzo, Senator of Rep. So the accused person. And our conference has resolved to indicate to the court that we record the following preliminary objection. Before Your Honor was previously charged of the same counts, that is count number 1 up to 6, in criminal case E715 of 2021. Subsequently, Your Honor, the DPP exercised his powers under section 87 plus paragraph A and withdrew that case. Well, Your Honor, we have no objection to our client taking plea in respect to count 1 to count 7 to count 6. Our objection is in respect of the mischief being perpetrated and the abuse of power being perpetrated by the DPP by invoking section 121I of the Penal Code. It was withdrawn under section 87A. So our simple application, Your Honor, when a case has been withdrawn under section 87A, is the DPP permitted by the law to introduce new charges in the same file, or is the DPP limited to the charges contained in the initial file? You know, I leave it to Mr. Jomo and Mr. Manzo to proceed, and my colleagues. Perpetrating through this charge sheet and the mischief.
No, let us take the plea first.
Because
all that will come after the plea.
Our objection is on this basis, Your Honor. It's under sections 87
I need things like this.
by the DPP. For one reason, Your Honor, as correctly put by...
If you want to respond to what she's saying, then I have to allow her to finish talking and then respond.
The sheet has been furnished to us. We have a copy of the charge sheet. And all the counts, if you look at count number 7, as he takes the plea.
Your Honor, there is nothing before you. Before he takes the plea, you cannot listen to anything.
It's a matter that is relevant.
Let us follow the procedure, please.
Because this plea or the charge sheet is introducing a matter that is already before the court. We have incited a case number E715 of 2021, and that file is not before the court. So that the question that the court should be asking itself, even as you look at the plea, is what the status of this particular matter. We are bringing a new charge sheet with a new charge, an account on a matter that is already before the court. This file has not been available to the court.
Counsel is misleading you, my Honor. Counsel is misleading you. There is nothing before this court. No, I will not allow him to mislead the court. Because the matter was withdrawn, and this is fresh.
Let me just finish. This court, even if that matter, Your Honor, is withdrawn, that is part of the record. So that, Your Honor, the accused person is required to plead to a charge on a matter that is not before the court. He has no advantage of saying yes or no on a charge, on a file that should be before the court. For him to respond to this, Your Honor, as a plea, he's supposed to say, I plead guilty or not guilty. How can he respond to this particular charge on a file that is not before him? Has he been given that particular file, Your Honor? I can count without the file being in court.
This is also something else, and I respect the directions of the court. What happens to a case that has been withdrawn under section 87A? Is the DPP supposed to bring new fresh charges, or is the old matter revived? That's a question of law, Your Honor, I wish you to determine.
Please.
Close its eyes to the abuse being perpetuated by the DPP. Because that is the question. The abuse being perpetuated by the DPP. We cannot allow it to pass the eyes of the court.
James Mwangi, unashtakiwa na kupatikana na dawa za kulevya ambayo ni kinyume na sheria. Maelezo ikiwa ni kuwa tarehe 18 mwezi wa Februari mwaka huu, ikiwa ni masaa ya usiku, ukiwa Dungeri Shopping Center hapa Kiambu County, unaweza kukataa kutoa.
I believe everybody is there. I just want to write quorum as before.
Yes.
With the intent to receive forged a Kenya National Examination Council certificate, to wit, a Kenya Certificate of Secondary Education Certificate, serial forgery contrary to Section 345, as read with Section 349 of the Penal Code, the particulars being that between September 2011 and April 2012, at an unknown time and place within the Republic of Kenya, with the intent to deceive, forged a Jomo Kenyatta University of Agriculture and Technology certificate of participation in the East Africa Universities Accession Project, serial number JKU/Kenneth/E1/2011 to 2012/C6, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have a third count, that is forgery contrary to Section 340. Excellence certificate from the Department of School of Human Resource Development, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true?
Not true.
You have a fourth count, that is uttering a false document contrary to Section 353 of the Penal Code. Seventh count, that is failing.
You know, that's why whether that count discloses an offense. The accused person is charged with the offense of failing to attend court, contrary to Section 121, subsection 1, paragraph I. You know, the reading of that section in the Penal Code, it's our humble submission that the same does not disclose an offense that can warrant the accused person to plead to. Your Honor, our application is backed by Article 50, Clause 2, Paragraph N. The judge does not square out with the law. And that is a prejudice our client will suffer if he is allowed to plead to an offense that is alien in law. And of course, you may not doubt the mischief by the DPP. It's so that this can form the basis upon which our client will be denied bail. They will say there are compelling reasons to deny our client bail on the basis of previous absconding. This application itself is also anticipating the ability of our client to enjoy the rights under Article 49.
I do object. Council has entered into the arena of bail. We have not...
No, I am not there.
Yes, you are there. And even purports to amend the law by correcting what is printed on the law. Let him address the section is contesting.
The objection lacks basis. That is why the court has not pronounced itself. Your Honor, the law provides for the ingredients. What are the ingredients in this application, this count? It is that on the 29th, between 29th July 2021 and 29th August 2022 at Kiambu, within Kiambu County, being an accused person in Kiambu Chief Magistrate's Court, is, number this, failed to attend court on numerous dates that the matter had been fixed for hearing and mentions without any lawful excuse. Count does not disclose any offense that is known in our law. We rely on the case of facts and create law. When Article 96 provides that the only person who has the capacity to enact any law is Parliament. In that respect, Your Honor, I invite my learned friends would wish to object to the accused person pleading to an offense that is not known in law. The section does not provide the question of failure to attend. It provides for disrespect of judicial proceedings and judicial officers. Permit me, as I pen off, to submit that this is an abuse of the court process meant to bring before the court compelling reasons that may require the court to deny our client bail.
Unless that file is placed before you, then you wouldn't have the benefit, or under Section 6, whereby the accused person, that law requires, should be given an opportunity. And if a judgment had been passed, also given an opportunity to appeal on it or explain themselves. That, Your Honor, has not happened. And therefore, this particular charge has facts which are administrative by the court in their actions. As much as they are very independent, their actions must also be fair under the Constitution. And therefore, without the perusal of this particular file, it will not be fair to charge the accused person with this particular offense, which we submit does not exist in law as it is framed.
Thank you for. Thank you.
The manner where a party is given a chance and the other party is given a chance to respond. I think it is important that we know where we are at any given time in the proceedings. If our learned colleagues for the defense wish to us to move to canvassing bond or bail, then we proceed with plea taking in count number 7, so that we know where we are. And I think also.
Do you want us to proceed with?
Can it really be said that the Office of the Director of Public Prosecutions is abusing its power in a case which is the use of the word mischief? Mischief, that is a term that we in our.
As you distribute. So I think the only issue here is there's any objection to him going home.
The High Court order in High Court Miscellaneous 28 of 2025, the accused shall be released on the same bond terms until tomorrow, when the court will deal further with the issue of bail or bond, being as it were there is a state officer, and the court believes that he will attend court for ruling in further orders tomorrow. Mimi siku hizi sijui watu. So I don't. Communication, you can come at 10.
10.
Yeah.
You don't just litigate and shoot in the dark.
Congratulations.
Zero makes me look bad. Unipewa njia tafadhali.
Msitufuate. Tuko pamoja. Anatoka sasa. Msitufuate. Tunakuombea sana. Tunakuombea.